Before we do that, I'll remind anybody who's watching, and I hope somebody is, that we have got some time towards the end of this when we will be taking questions, and they're going to magically appear on my laptop here. So if there are any issues which you want to raise, or indeed any points you want to make, then please get in touch in the appropriate way. Sue, can science give us the answer or not?
Well, in some cases, absolutely, but I think every forensic expert would agree, regardless of their expert evidence type, that no case should be tried purely on forensic evidence alone. And indeed, there are a number of appeal court rulings that state exactly that, particularly in my area, which is DNA profiling. And really what I wanted to talk about today was really not the fact that the legal aspects, obviously, and the preventive measures are not really the area of child protection that my work touches on, but actually those later stages where there is a forensic question to answer, where perhaps there is a question of whether there has been abuse of a child, then this is the area that I work in, and I have dealt with a large number of sexual offence cases, a number of those with child victims. And I just wanted to raise a few concerns about what is happening in the current forensic market, because I'm sure everybody's aware of the recent closure of the Forensic Science Service. And this, to me, raises a few concerns, as I'm sure it does to other experts. And I wanted to talk about the Sexual Offences Service that the Forensic Science Service set up in 2002, because as far as I can see it, this had a huge impact on the way that we deal with these types of cases. And this was a service that was set up in response to a joint thematic that was published in April of that year on the investigation and prosecution of rape and sexual assault cases. And this highlighted specific issues, and they related to the medical environment, the investigation process, the prosecution process, and the court environment. And in response to that, the Forensic Science Service set up this service, and I was actually involved in implementing that service from November of 2002. And it involved improving the forensic contribution to that type of case, and also assisting police investigators to improve the effectiveness of their investigation. There were a number of elements, I won't go into all of them, but one of them was improved communication, so really encouraging a joined-up multi-agency approach, particularly linking up with CPS, linking up with the police investigators to see how we could do this better, how could we improve this process of investigating these types of cases. And it does worry me that a number of the services that were offered, things like intelligence information provision, geographical mapping, the possible linking of sexual assault cases, the wealth of information that was recorded on the Serious Crime Analysis Section database has now been lost. I'm not sure what will happen to that data. I do know that the other providers do offer a sexual offences service, but inevitably, due to budget cuts across the board, I would question whether these additional services are also offered as part of that.
So in practice, what does that mean? Right, cases will be investigated on their own and not looking for links to other cases, is that?
Well, it may be that some of this additional information isn't being recorded or isn't being picked up on. The information will all be there in the forensic case files, but nobody's looking at that information. There is a concern that for budgetary reasons, complex forensic cases are being dealt with by what is essentially a cheaper route, where the body fluid tests and the DNA tests are carried out, but the interpretational issues aren't being addressed, and there is a risk that they will later be addressed at court, or perhaps even that they will be dropped before those cases go to court. That would be a huge disaster for the victims if those questions haven't been considered. in advance, or the scientists who are dealing with them are purely scientists who are addressing the issue of source. What is the source of this DNA, or what is the source of this body fluid, and aren't answering the more complex questions, and perhaps aren't in a position to answer those more complex questions.
What would the more complex questions be?
Well, they would be matters that the court would want answered, the more complex matters of how has that DNA been deposited, how has that body fluid got there, do these findings fit with the alleged set of circumstances, or could they also be possible given whatever the defendant's view was, the defendant's version of events was. And without answering those questions, it's very unclear as to whether your source level findings, your matching DNA, actually means anything within the context of that case until you consider what we would term those activity level questions. And I am not convinced that that is always being done due to issues of cost.
Helen, does this mirror your experiences?
It does, very much so, yes. Certainly, in going back to the point made earlier about trial by expert, I mean, one of the things that most forensic scientists are absolutely passionate about is the idea that they are impartial and that they should be giving a balanced view to both the criminal justice system and other agencies about the relevance and interpretational meaning of their evidence. And you're talking about the drugs case, where hair testing case. I mean, really, experts should be providing a balance of what significance that can bring and how much it can actually, how much information can actually be drawn from that. So really, in that situation, they should be telling you about the reservations they might have, as well as the potential usefulness. And then it's up, obviously, for the court to decide, and other experts, and bringing in expertise from all different agencies as to really how significant that is in the case. As Sue was saying earlier, I mean, I'm also a DNA scientist as well as doing other evidence types, and I'm certainly seeing in the last couple of years, and it's getting more and more prevalent, is that in order to manage lack of finance, budget cuts, things like that, the police and other agencies are having to make some very difficult decisions about where they spend their money. And one of the areas that we're certainly seeing, as Sue mentioned, is this tendency to, at least in the initial stages of the case, to look at just testing for DNA, or doing some very simple test that they hope will just bring the answers, and that they can spend minimal amounts of money and then present that to court. Certainly in my experience, what I'm finding is that when it actually comes to court, the scientists in question that have been asked to do this work are actually being asked what the court actually requires, which is, how's that scientific evidence been obtained, what does it mean in the context of the case. And unfortunately, the way a lot of forensic providers are set up these days, with different mechanisms for proceeding with work and carrying out testing, is that you either have a sort of a quick, slick route that you put the cases through, which is cheap and cheerful, as it were. It brings results, but doesn't necessarily give you that detailed professional interpretation that the courts might be looking for. Or you go down the more considered route, where you devise a strategy to start with and discuss with all the different agencies and experts ahead of time to work out the best method for court. Now, in a lot of cases, and especially in sort of child welfare cases, I believe it's very, very important that you have that very considered strategy to start with.
And what would be the best way of doing that? Because listening to you all talk about the processes, it does feel that a system which is really should be not consensual, but should be seeking everybody actively to get what's best for the child. Yet there is a level of people being adversaries in that, and quite rightly, people being properly represented as parents and children being represented. What what would be the ideal? Because we're all talking about, it's costly and we're not able to do perhaps what we'd like to do. But from my perspective, and I think very much from what Debbie was saying earlier, we've spent in the past large amounts of money on experts when perhaps we could have had the social worker doing it. How could we better use what we've got to get that more considered approach? What's the ideal way forward?
A few years ago, it was put forward that we had a tripartite agreement between the CPS, forensic science providers and the police. Unfortunately, certainly in my experience, this doesn't seem to have worked very well. The police and forensic providers tend to have a lot of dialogue, but CPS doesn't seem to come into the equation until much later on, quite often at the point at which the case is going to trial. And CPS are obviously looking at all the evidence in the case, not just forensic evidence, experts, social workers, etc., all the other people that have an involvement. And that dialogue is just one way, or non-existent. And I think really what we need to do is ensure that all the agencies are aware of each other and aware of their constraints and abilities and how we might all benefit each other. So I think there'll be a real benefit to all the different agencies talking to each other informally. And this webinar obviously is a brilliant means of actually getting some of that across. But also, in the case of the actual case under investigation, I think there should be more opportunity for experts to have some form of dialogue, either via an intermediary such as CPS, or themselves to be able to talk and identify what best to do. Because I think in a lot of cases we could come up with a solution that's much more cost effective than the processes that we're currently constrained to, that are supposedly saving money but only sort of in each individual sort of field. So.
And what's happening these days about experts being instructed? Because I remember horrendous cases where you'd end up having to have experts meetings and there'd be about 9 experts in the room, and some of them looking all at the same thing but trying to come to a view on it. What's your experience these days, Debbie?
Certainly in recent, I would say even in the last couple of years, since we've really had to think very carefully about how much by way of resources there is out there available for these cases and how to best use those resources, as Helen was saying from her field. I think the courts are now asking for much more information than they ever were as to why that particular expert is needed. What is their field of expertise? Why do we need them? How will they take the case that much further? Don't know, Lorna, do you find that rather than where perhaps we used to go in on the nod almost, and you would say we want this expert and the courts would say yes, now that the courts are really investigating much more closely. And that's come directly out of Monroe, if not before. And Laura and I were saying just before we came in, there's an interesting, there's a pilot that's just started over in central London, really to driving towards the government targets of 26 weeks to try and see if we can have a case that can go through in that time. Now, as I think anybody working in childcare will tell you that no 2 cases are the same, and one case where longer is needed may be a benefit to that family to give the parent who might have drug misuse or alcohol misuse issues, time to demonstrate that they can put that right. But in other cases, the case needs to finish as quickly as possible. So it'll be very interesting to see with this pilot how that the decisions in those particular cases will affect other cases in terms of the cascading of the decision making and what the judges that are dealing with not in those pilot cases will do in the rest of the work that goes before the courts. I certainly in terms of experts, and I think we're talking about two very different areas here. We've got the forensics and how that feeds into a case where there's been child sexual abuse, violence and such like, where there is forensic, and the experts where we have psychologists, the adults, and those types of experts, which tend to come in further on in the case. For example, I've got a case running at the moment that I was horrified, and I think that how long it's taken for the police to actually be able to send and to budget for a number of computers to be sent to a forensic laboratory to be analysed for indecent images. And it's a year since that investigation began and those computers were seized. And they've only been able to budget to investigate 1 laptop. Now, that has the competing tensions between the police investigation and the childcare proceedings, because we're in a childcare case which is reliant upon information from the forensic teams out there. And we really didn't have the sense when we were last before the High Court as to how much really that the forensic team really knew that this was urgent, or the police knew that this was really urgent from our perspective, going back to the question of delay for these little children. So I think in terms of how we develop that, I think I would definitely advocate more of what we have, and they don't happen very often, joint directions appointments where you perhaps have the child practitioners going